All right. Good afternoon, everyone, and welcome to today's webinar, Reproductive Healthcare, Litigation, Privacy, and Public Health Updates Post-Dobbs, brought to you by the Network for Public Health Law. My name is Daniel Wacker, and I'm the Program Development Associate here at the Network's National Office, and I'll be your host for today's webinar. We strongly encourage attendee participation by using the Q&A function at the bottom of the screen, and we'll be answering questions at the end. So if you enter them, our panelists will be answering them at the end of the session. So don't worry, we will get to answering them. Also, I'm then going to pass it off to Catherine Schutz, who is the staff attorney for the Eastern region of the network, and she will be the moderator today. She will introduce the rest of the day's panelists. So Catherine, over to you.
Thanks, Daniel. I'm Catherine Schutz. I'm the staff attorney for the network's Eastern region. And today you'll hear from 3 members of the network's reproductive healthcare team. First, we'll have Kathy Hoke, who is the director of the network's Eastern region and a professor at Maryland Carey School of Law. And Kathy will explain state-level litigation related to state constitutions and the right to abortion, and mention a couple federal cases related to access to medication abortion. Then we'll have Stephen Murphy, who is the Deputy Director of the network's Mid-States region. Stephen is a healthcare data privacy expert and will describe state efforts to bolster privacy of reproductive health records and ensure they are not used against patients or providers for seeking or providing reproductive health care. Then we'll have Joanna Suter, who is the Senior Staff Attorney with the network's national office, leading the network's reproductive healthcare work. Joanna has been interviewing local health department staff working in reproductive healthcare access and will report on how local health departments are operationalizing ever-changing state laws regarding sexual and reproductive health to best serve their communities. And so remember to just put your questions in the Q&A box at any time, and we'll go to Kathy first. Kathy, you're muted.
Of course I am. Thank you, Catherine. Thank you, Daniel, for getting us started, and Catherine for moderating today. And I just want to confirm, Catherine, you can see my slides?
Yes.
Terrific, thanks. So as Catherine indicated, I'm going to talk about state level litigation, maybe a little bit of federal at the end, depending on timing. But I want to first situate things with where we were and you know, how we've come to even have to have this conversation today. So, you know, in 1972, the Supreme Court decided kind of the abortion case of Roe versus Wade. There's lots of case law that came after that kind of brought parameters to this right. But what's important to know is that the Supreme Court then used the 14th Amendment's due process clause to find this right to privacy, and that right to privacy encompassed the right to abortion. And of course, again, later case law kind of gave us the parameters to what that right looked like, but pretty much an absolute right leading up to viability. The right was, of course, then not absolute. There was a balancing between protecting the health of pregnant people, as well as then protecting the potentiality of human life. So again, thinking about that right to privacy as the source of the power, source of the right to abortion in Roe versus Wade. Flash forward almost 50 years later, and in June of last year, the Supreme Court decided Dobbs versus Jackson Women's Health, or the Dobbs case as it's now obviously referred to. The facts of the case, it's interesting, there were lots of states wrangling to get to be first with a Supreme Court friendly comprised to removing this right, but Mississippi got the nod. They had passed a 15-week abortion ban, so pretty much after 15 weeks, abortion was banned, with exceptions for medical emergency described a certain way in their statute, or severe fetal abnormalities. There was zero question that this was in violation of Roe versus Wade. They did it knowing that it was in violation of Roe versus Wade and hoping to get to the Supreme Court to challenge this. And the Supreme Court, of course, did take up the case and found, overturned Roe and said there is no constitutional right to abortion. There's a ton of language in the myriad Dobbs opinions that are out there, the main opinion, concurring opinions, dissenting opinions. What's really important is that the Supreme Court said that the right to abortion is neither deeply rooted in the nation's history nor an essential component of ordered liberty. That's now language we're seeing used in conducting 14th Amendment analysis in other contexts, right? So the right to privacy that the Supreme Court had recognized in Roe is in doubt in total, not just with respect to the right to abortion. So if you hear about it mentioned with respect to other reproductive healthcare access issues like birth control or other issues such as same-sex marriage, you're right, there are concerns about whether that right to privacy exists at all. So going to talk about a couple of different kinds of cases here. First, there are cases that were prior to Dobbs. They were all post-Roe, but prior to Dobbs, where state courts, or state constitutions provided the right to abortion. So it's okay, Dobbs got decided, not okay, but Dobbs got decided. In some states, individuals could rely on a state constitutional right to abortion. And so we'll look at some of the cases where there was a pre-existing state constitutional right. And then there are now post-Dobbs challenges based on state constitutions where restrictive abortion bans have been passed and individuals are challenging them. They can no longer challenge it based on the federal constitution, but they can challenge it based on their state constitution. So what you see on your screen now is a list of state Supreme Courts that before Dobbs was decided had found a right to abortion protected in their state constitution. So between Roe and Dobbs, these states that you see here all have a Supreme Court decision in their state that says there is a right to abortion embedded in the state constitution. Most of them are based on the so-called right to privacy that comes from a due process clause in their state constitution that looks quite like the federal constitution. So while Dobbs doesn't undo these decisions, for those that are based on the same language that was in the federal constitution that they find in their state constitution, there is at least concern that the Supreme Court in those states would overturn their previous decisions for the same reasons that the Supreme Court overturned Roe versus Wade. But it doesn't happen automatically. Why are Tennessee and Iowa at the bottom with the question marks? They were in these categories where there had been a protected right to abortion in the state constitution, but in Tennessee, a court in the year 2000 had found a state constitutional right to abortion in Tennessee, and the voters took to the ballot and changed that and said, no, our state constitution does not have a right to abortion. And so that state court decision got changed by the voters. And in Iowa, the court actually overturned itself. So in 2018, the Iowa Supreme Court had found a state constitutional right to abortion. And in 2022, a week before the official decision in the Dobbs case was released, remember, there was a leaked opinion, a couple of months earlier, but a week before the official Dobbs opinion, the Iowa Supreme Court overturned itself and said there is no state constitutional right to abortion in Iowa. So that's where we are in those particular states. So prior to Dobbs now, those were all states that had pre-Dobbs cases. There are at least 10 states. I'm not going to tell you this was a comprehensive analysis, but at least 10 states where there have been challenges to severe abortion restrictions that are based on state constitutional provisions. I first want to give you an example of a state with what we call a trigger law. There are states out there that after Roe and before Dobbs had passed laws saying, if Roe versus Wade is overturned, this law goes into effect. And so essentially North Dakota did that in 2007. And I like that I said North Dakota as if I was from there when I'm not. But North Dakota passed a near total ban in 2007 saying, should Roe versus Wade be overturned, this is the law that we want to have into effect. So that's what we call a trigger law. So what happened in North Dakota? Well, the North Dakota Supreme Court upheld a preliminary injunction preventing this near total ban being triggered into effect, saying the state constitution, so sure, Roe versus Wade was overturned, but saying the state constitution protects some right to abortion, right? They don't say there's an explicit right to abortion. It's all constitutionally protected, but they found this near total ban that didn't have sufficient exception for protection of the pregnant person's life to go too far. And so in that balancing, they said there's at least a right that protects you when it comes to kind of a life-threatening situation for the pregnant person. And that this ban was not, because it didn't have a sufficient exception, was not narrowly tailored. And so they, again, reversed or prohibited the law from going into effect based on state constitutional law. I will say the rest of the story is that North Dakota legislature did pass a subsequent ban, and they added some limited exceptions that are similar to exceptions that we see around the country for medical necessity. That case that was challenged again, and that case is pending, but their trigger law did not go into effect. Now, this is an example of what I'll call the first example of a trigger law. There's nothing we could have done about it. It was on the books, right? This is a law that came onto the books really in knee-jerk reaction after Roe versus Wade. This is the first state that passed. This is the first state that passed a post-Dobbs, very restrictive, near total abortion ban. This is a reminder of why it's important who you elect to office. Here, the state Supreme Court upheld the ban against a challenge based on the state constitution. This law is now in effect in Indiana, and all 6 abortion clinics in the state closed. So there is virtually no access, really, to abortion in Indiana. I will note that there is a pending case in Indiana challenging this near total ban on other grounds based on the state's Religious Freedom Act, saying that this violates certain individuals' state constitution protected religious rights. I'll get to that, those kinds of arguments later, but the law is in effect while that case is pending. So that's an example of, be careful who you elect. Here is an example of the importance of who comprises your state Supreme Court, and this comes out of South Carolina. Pretty quickly after the Dobbs decision, South Carolina passed a 6-week abortion ban with very limited exceptions. However, immediately upon challenge, based on the state's constitution, the state Supreme Court found in January of 2023 that that ban violated the state's constitution, the right to privacy, encompassing the right to abortion in South Carolina, January 2023. But in August of 2023, there was a new law passed that looked almost like the old law, the previous version. It got challenged, and in August of 2023, the exact same court, the state Supreme Court in South Carolina, with the exact same constitution, said, no, there is no right to abortion. There's no right to privacy. There's no right to abortion in the state constitution in South Carolina. So how did this happen? If the law was almost exactly the same, the state constitution didn't change, it went to the same court, well, the members of the court were not the same. Principally, what's most important was one of 2 swing votes that found the law unconstitutional the first go round was by age required to retire, and she did. And now there are no females on the state Supreme Court in South Carolina. Last I checked, it's the only state that has no female representative. She was replaced with an individual who everyone knew would go the other way on this. The other swing vote, if anyone really wants to talk about that, I can talk about the confusion between his 2 decisions from the one case to the other, but it doesn't really matter. because at the end of the day, he voted to, this time, to uphold the law and find no state constitutional right to privacy, no state constitutional right to abortion. There is a new challenge pending based on vagueness, saying difficulties in interpreting and applying the limited exceptions that are available make the law unconstitutional because it's too vague. But the law is in effect while that case is proceeding. I just thought I should throw in a little ray of sunshine then. And this comes from Montana. And it's a post-Dobbs case based on the state's constitution. Montana was on that list of states where previously the state Supreme Court had found a state constitutional right to abortion. And here, in response to the Dobbs case, the state legislature had passed a law prohibiting advanced practice registered nurses from providing abortion care. Very commonly around the country, APRNs are able to successfully provide abortion care, particularly medication abortion. And so it would be very restrictive of access to abortion in Montana to not allow APRNs to provide that care. And here the court said, our state constitution guarantees the right to seek abortion care, and here from a qualified healthcare provider of their choice. I highlighted here in orange language that I think is really important here, that abortions remain one of the safest procedures when performed collectively by healthcare providers, including APRNs. So importantly here, the state constitutional right was actually it's considered pretty broad here, that it was even a basis to strike down this restriction. So there are lots of pending cases on constitutional grounds, some where there is a temporary injunction against enforcement of the ban. And you can see Utah, I probably should strike Ohio there, Utah and Wyoming. Why should I strike Ohio? The voters reversed it, and the voters did embed in the state constitution in Ohio recently a right to abortion. Cases pending on state constitutional grounds where the law is in effect, you can see here. What about Michigan, Kathy? Shouldn't this be on the list? It was on the list at some point, but the Michigan voters took back their power to say, we're not going to leave it to the courts. We are going to take control here, and they passed a constitutional amendment to make sure that there is a right to abortion found in the Michigan Constitution. Again, Ohio did that. I should have updated this slide, and I'm not sure why I didn't notice that. Apologies to my friends from Ohio, some of whom I know are on this call. Other state challenges or challenges based on state law post-Dobbs. I mentioned this earlier. State Religious Freedom and Restoration Acts, or state RFRAs, as they're referred to, or state constitutional provisions, so either laws or state constitutional provisions on religious freedom have been used as the basis for lawsuits around the country, saying this abortion restriction is so severe that it conflicts with the religious belief that actually prioritizes the health and well-being of the pregnant person, who should be able to get an abortion in circumstances that wouldn't be allowed in the state law. You can see the example I drew here from the Indiana case, that for, bless us all that we see the religions coming together here in this Indiana case. Judaism, Islam, Unitarian Universalism come together and say that for their religions, we require abortion care to be provided if it jeopardizes the mental or physical health of the pregnant person without it necessarily being a life-threatening situation. The state laws only allow it for that life-threatening situation. And so there is this case in Indiana is pending. There are other cases like this around the country. We haven't gotten decisions in any of them, so stay tuned kind of on that. And then just a couple of new wave of cases. People who were denied lawful and necessary, potentially life-saving medical care. So in Texas, Idaho, Oklahoma, Tennessee, where they have very restrictive abortion laws, there are patients who are suing. They're sometimes suing medical professionals, but kind of in cahoots, if you will, with the medical professionals, and or suing the state and saying, this law is either vague or its application, because of the fear that it invokes in the medical providers, is actually, I was entitled to care, but I was denied it because the medical professionals rationally fear that they don't know where this line is of life-threatening. And so they're joined by providers in some of those cases. There's also what we call an EMTALA, or Emergency Medical Treatment and Labor Act, a federal law that requires hospitals to, any person who presents an emergency, that they be provided appropriate stabilizing care. And this is a patient suing in Oklahoma, saying that their EMTALA right should have meant that they received an abortion when they presented, but they were denied that based on Oklahoma law. So we're seeing a conflict here between federal and state laws. A couple of challenges for vagueness. I referenced one earlier, but lots of states, this, life of the pregnant person standard, the life-threatening, et cetera. There is, medical professionals are frustrated, in addition to, organizations working to protect reproductive healthcare access. And, so they're challenging these laws on state grounds, saying they are too void to become effective. Others you can see here on the screen. Again, these are very specific to these particular states. Just an interesting case out of Guam. Guam has a 1990 law that prohibits medical professionals from giving advice to clients on seeking abortion care. There's actually no abortion care provided on Guam, but medical professionals aren't even allowed to tell people on Guam that they could seek abortion care for certain, medical conditions during pregnancy or otherwise. And so that law, frankly, is enjoined right now, but the Attorney General in Guam is seeking to remove that injunction. Then I just want to turn just quickly, because folks are interested in knowing a little bit about the mifepristone cases. So I'm just going to touch on them here and then turn it over to Stephen. First, there are these competing cases. Mifepristone and misoprostol are the medications that comprise medication abortion. But here you can see two cases, one filed in federal court I'm blanking on the state, but it's in the Fifth Circuit. And here is where there was challenges to the FDA's approval of medication abortion drugs, saying they should have never approved of these drugs. The court said they couldn't go back to the approval, which was done in 2000, but the court, in this case, the Fifth Circuit has said FDA's rules that they changed to make medication abortion more accessible through telehealth, kind of actually using less of the drugs, et cetera, those rules can't go into effect. I'm sorry, the 2023 rules can't go into effect, but only the 2016 rules can be applied. That is actually stayed, and the Supreme Court is deciding whether to take the case. I imagine they will take the case, but that decision says the 2023 rules cannot go into effect. Again, it's not that decision is not in effect right now, but that's what it says. Flip side, we have a case that was filed in the Federal District Court in Washington by 17 states and the District of Columbia, saying, we think the FDA has been too restrictive in their controls, their protocols for the use of medication abortion drugs. And we want to, challenge that. Meanwhile, while we're challenging that, they got an injunction that says the FDA can't pull back anything, make the drug more restrictive than the 2023 protocols provide. So we have these competing decisions in this area, which is again why I think the Supreme Court will probably grant certiorari. We do see some state court litigation in this space as well with respect to mifepristone. And you'll see in West Virginia, there's kind of a split decision, if you will. One of the manufacturers of mifepristone claimed that West Virginia's law that didn't allow access to mifepristone set different rules for access to mifepristone when it was available, was preempted by federal law, that the federal rules for use of mifepristone, which allows it to be used past the 6 weeks that is allowed in West Virginia, that federal law should prevail. The court said no to that. that a state can restrict abortion below where mifepristone is available. But the court importantly did say, but West Virginia can't set its own rules for the use of the drug for when it is allowed. So under 6 weeks in West Virginia, mifepristone is available, but under West Virginia law, they said not by telehealth. And here the court said no. The FDA rules say telehealth is allowed, and that does then preempt in West Virginia. Similar case, or somewhat similar case out of North Carolina, where it's really a head-to-head. Does the FDA's approval of mifepristone preempt the state restricting its use during some of the time that otherwise under federal law it's available? This is all about 6 weeks versus 10 or 11 weeks. And then just quickly in Wyoming, there is a straight up law prohibiting medication abortion outright, period, even where abortion is allowed in Wyoming. That case is proceeding, but while it's proceeding, the court has stayed enforcement of that law. So medication abortion is accessible now in Wyoming. Well, practically speaking, perhaps not, but under the law, it is. I skipped through my last slide in the interest of time, but this point here is a lot of the issues that we're talking about on these federal questions will be at the Supreme Court to see how they get decided. And on that note, I'm going to turn things over to my colleague, Stephen.
Great, thanks, Kathy, and thank you for that great overview. Let me just share my screen here so that folks can see my slides. But in the meantime, while I'm doing that, I'll just remind folks that you can enter questions in the Q&A, and we will be happy to answer them. I wonder, I think you guys can see my screen, but maybe one of my co-presenters can let me know that you guys can see my screen. I see it thumbs up, so we're all good. So I am going to talk today on privacy of reproductive health records in the fallout from the Dobbs decision. And really, there is a primary concern here around records of individuals with the potential for pregnancy, and that is that they might fall into the hands of prosecutors or investigators in states that are adverse to reproductive health care. And this is a real problem, as we'll see in just a moment from a case in Indiana. But we'll see some state efforts, and we'll talk about some state efforts to bolster the privacy of reproductive health records following Dobbs because of this concern around investigators and prosecutors, and other concerns too around folks getting access to health information. So these are some headlines from 2022, from the summer and fall of 2022, and involved a very disturbing case of a 10-year-old that was the victim of rape in Ohio and who traveled to Indiana to have an abortion. And this made headlines at that time in the fall. And the reason why I'm showing the headlines here is because in that case, the Attorney General in Indiana took great exception to the news and to the physician that was providing the care in that case. The physician provided some press conferences in which she confirmed that she was participating in the care, but did not disclose any individual level information. Nevertheless, the Attorney General Indiana sought the records of the 10-year-old in order to pursue action against the physician, first going to state court, and then ultimately the case went to the Medical Licensing Board in Indiana. And ultimately, the physician was sanctioned, but the Attorney General, as it turns out, was also sanctioned by the Attorney Licensing Board. But it's a good illustration of where prosecutors can pursue the records of individuals in order to take adverse action against the patient, or in that case, the physician. So I'm going to run through several case updates from, or rather, state updates from around the country. And we'll start with California here, that was particularly active in passing laws after the Dobbs decision to bolster the privacy of reproductive health records. And in fact, on the day that the Dobbs decision was released, and Kathy mentioned previously that the decision was, of course, leaked a couple of months before it was issued. But on the day that the Dobbs decision was issued, the California governor, Gavin Newsom, and the governors of Oregon and Washington published a commitment to protect the rights of individuals to reproductive health care. And as part of that commitment, also stated that they would protect the privacy of reproductive health records. And so here we see this first bill here from California that was passed and was signed by Governor Newsom on the 27th of September of last year. And that law prohibits release of information interfering with the right to an abortion under California law, or to enforce a foreign penal civil action, which is defined in the law as a civil action authorized by the law of a state other than California, in which the sole purpose is to punish an offense against the public justice of that state. And so that was the first one. And then on the same day, Governor Newsom signed Assembly Bill 1242, which prohibited ex parte orders for interception of electronic communication. So think of things like wiretaps, and it prohibits also communication services from responding to out-of-state warrants with customer data when the case involves an abortion, excuse me, that is legally performed in California. So then fast forwarding to September of this year, and California passed AB 254, and that particular law requires mobile apps and websites that collect reproductive health and sexual health information to comply with the California Medical Information Act. And so that is significant because, as many of us know, HIPAA, the Health Insurance Portability and Accountability Act, which applies to covered entities and to protected health information, typically does not reach apps and websites and our browser history, for example. But so this law is attempting to apply more restrictions to apps and websites that collect reproductive health records, so things like period tracking apps, and requires them then to comply with the privacy provisions of the California Medical Information Act. It also changes the definition of sensitive services within the law to include reproductive health and gender-affirming care, actually, and so applies many of the provisions of the California Medical Information Act to those apps and websites. And then also on September 27th of this year, California passed AB 352, and that particular law requires businesses that maintain electronic health information systems on behalf of a healthcare provider to include certain features if the information systems collect reproductive health and also gender-affirming care information. And so those features have to be enabled by July 1st of 2024. And they include the system having the ability to limit access to abortion and contraception and gender-affirming care information to authorized persons, and also preventing disclosure to people that are outside of California of that same type of information. And then also another one of those features that have to be enabled is to be able to segregate that type of information from other types of information in the record. And then also it has to be able to automatically disable access to that type of information by individuals that are outside of California. So there's another part to that particular AB 352 also, which is a non-cooperation provision. And this is something that we see in California and also some of the other laws that we look at. But generally, this prohibition on cooperation with out-of-state agencies that are conducting investigations into abortion that is legally performed, in this case in California. And in this case, this particular law applies to healthcare providers and health services plans. In other jurisdictions, like the District of Columbia, for example, there are prohibitions on government agencies and departments from cooperating with out-of-state agencies. So this one is interesting in that it applies to healthcare providers and health service plans. So then Colorado also passed Senate Bill 188, and this particular law prohibits courts and attorneys from issuing subpoenas relating to out-of-state proceedings relating to abortion care and gender-affirming care, although it doesn't prohibit investigations into criminal activity around those things. But if there's no criminal activity involved, it does apply. And that also prohibits search warrants and summonses and ex parte orders for wiretapping relating to investigations or proceedings involving reproductive health care. Connecticut is another state that was one of the first states to take action around protecting reproductive health records. And in this one that you see on the screen here, Connecticut Public Act 22-19, that law prohibits summonses for out-of-state criminal cases involving out-of-state abortion law, and also prohibits release of information from that's obtained from patients or from a physical exam of a patient relating to reproductive health care in any proceeding without the consent of the individual. And there are certain exceptions in which the consent is not required, including where the disclosure is pursuant to the laws of the state or where it's in defense of an action that's brought against the covered entity, or, for example, when there is an allegation of child abuse or neglect, that would typically trigger a mandatory reporting law. Illinois is an interesting case as well, where we have Illinois that is supportive of reproductive health rights, but it is surrounded by no fewer than 5 states that are not supportive of reproductive health rights, including Wisconsin and Indiana and Kentucky and Missouri and Iowa. And so this Illinois House Bill 4664, which was signed by Governor J.B. Pritzker in January of this year, prohibits court clerks from issuing subpoenas for out-of-state actions infringing on the right to abortion. So let's have a look at the next one then. We see in Maryland, Maryland in May of this year passed House Bill 812, and this one prohibits health information exchanges from disclosing mifepristone data, which, as Kathy explained, is medication abortion, but also prohibits disclosure of diagnosis or procedure or prescription information relating to abortion care, except if the disclosure is for the adjudication of claims or where it is to a provider with the written consent of the individual. So that one is significant because in our systems today, we push for more interoperability between systems in healthcare and in public health. And so this current climate post-Dobbs has given us some concern that the push for interoperability may lead to easier access to reproductive health records for prosecutors and investigators and other folks that might want to use the information against the patient or against the provider. And so this is Maryland's answer to trying to curtail inadvertent disclosures of that information through health information exchanges. Massachusetts passed HB 5090 in July of last year, and that is another non-cooperation law. It prohibits in-state law enforcement agencies from cooperating with out-of-state law enforcement agencies and any private citizen in relation to an investigation or prosecution around legally provided reproductive health care in Massachusetts. New York is another state that was particularly active in passing laws following Dobbs to protect the rights to reproductive health care, and including protecting the privacy relates to the provision of reproductive health care And you'll see here on the screen here, the Bill 1977, which amended CPLR 3119, which is New York's Uniform Interstate Depositions and Discovery Act. So that amendment resulted in no subpoenas in out-of-state actions relating to abortion unless the proceeding is brought by the patient. And there's some other laws from New York as well. So in the same law that was passed, this 1977, it added section 837-W, which includes another non-cooperation provision. So prohibits state and local law enforcement agencies from cooperating with out-of-state agencies where the matter is relating to a lawful abortion provided in New York, and also prohibits disclosure to out-of-state agencies except for where there is a valid court-issued subpoena or warrant. And so that's no disclosure of information relating to a medical procedure. And again, the exception is where there's a valid court-issued warrant or subpoena. New York's same 1977 also amended CPLR 3102, and that resulted in a prohibition on orders for deposition for out-of-state proceedings. So folks that are engaged in a proceeding out-of-state but are seeking the support of New York courts to obtain an order for a deposition if the matter relates to abortion, an abortion that's legally performed in New York, then the Supreme Courts in New York then are prohibited from issuing orders in aid of deposition. New Jersey passed Assembly Bill 3975 on July 1st of 2022, and this is another non-cooperation with out-of-state investigations. So specifically, this one applies to public entities and prohibits cooperation with interstate abortion investigations relating to the provision of reproductive care, or indeed also where it relates to even assisting or advising or inquiring about reproductive health care services. So no cooperation with interstate investigations in that context. Vermont, in May of this year, passed Senate Bill 37. That one focuses on some nomenclature from HIPAA, borrowing the terms covered entity and business associate. Those are the types of entities that are subject to HIPAA, but it's not unusual in privacy law to see terms that are borrowed from other law, including borrowing from federal law. And so this Vermont law prohibits disclosure by covered entities and business associates related to legally protected healthcare activity, which is defined to include reproductive health care and I believe gender affirming care as well in any out-of-state proceeding. And so that bar on disclosure to an out-of-state proceeding has some exceptions, such as where the disclosure is authorized by the patient, or where the disclosure is required by law, or where it's ordered by a court, or if the information is going to be used solely for defense of the covered entity or the business associate. So that's something else that we see in other similar laws too, that where there is a prohibition on disclosure of reproductive health information, there is often an exception where there's an action, a cause of action against the provider. In that case, the provider is not prevented from using the information to defend themselves. And then in New Mexico, we saw Senate Bill 13 in April of this year. That includes another non-cooperation provision, so non-cooperation with out-of-state investigations relating to legally performed reproductive health care in New Mexico. Also, that law prohibits submission of out-of-state subpoenas relating to reproductive health care to a court in New Mexico, and also prohibits any individual from requesting information from a third party, or prohibits a third party from providing information if the intent is to harass or intimidate an individual who is seeking reproductive health or their provider. And then in Nevada, this one kind of gets an honorable mention because Nevada passed, excuse me, passed a consumer health data privacy law in June of this year. This followed a similar Washington law, which was passed a couple of months beforehand, but it is a comprehensive consumer health privacy law, but it does call out reproductive health care and gender affirming care as types of health data that is covered by the Act, and it requires privacy policies on the part of entities that collect consumer health data. And those privacy policies have to state things such as that the information will not be used beyond the purposes for which it was collected, or rather to provide the services that are requested by the individual or where there is consent by the individual. And that is significant, the policies, because if an entity has privacy policies and includes provisions in there around how the information is going to be used or disclosed, then if the entity does not follow those policies and procedures, then there may be a cause of action for consumer fraud. And we've seen that on the federal level, where the FTC has taken action against some app developers, where they have had privacy policies that have stated what will be done with the information that's collected, and then they did not follow those policies or were not aware of what would happen to the data, given some of the contracts that they had with some data processors, for example. Then there may be a cause of action for consumer fraud. And in that case, the FTC did take some action. But this Nevada law also includes a right of the individual to confirm with the entity whether or not they have their data, and then also the right to request that their information be deleted. And the law does not apply to HIPAA-regulated entities, so covered entities and business associates under HIPAA, or if the information will be used just for public health. So there's a public health exception that's built in as well. And then the last one here is Washington. This is HB 1155. So this is very similar to Nevada and actually preceded the Nevada law by a couple of months. And that's very similar in that it requires privacy policies that protect the rights of consumers with respect to the information that's collected by these regulated entities. And so this, again, would apply to things like websites and browser histories, for example. So if folks collect that consumer health data, then they have to have, similarly, these privacy policies or certain rights that have to be granted to the individual. And also, the law does not apply to HIPAA-covered entities or business associates or public health. So that's it really for my presentation. As I mentioned, there are many steps that are being taken across the country to protect reproductive health records following Dobbs, including not or prohibiting the use of state courts to support out-of-state investigations and prosecutions, to limit disclosure of information. We've seen some consumer health privacy laws that apply to consumer health data that's collected. And then also, we've seen some creative lawmaking in California, for example, where they have applied the state's health privacy law to apps and websites that collect reproductive health data. So with that, I will stop sharing, and I'm going to hand things off to my colleague, Joanna, who is going to talk about some local efforts following the Dobbs decision.
Thank you so much, Stephen. As a reminder, as I am sharing, feel free to add your Q&A into the chat. Into the Q&A, sorry, or the chat. Q&A is the preference, though. Here we go. Okay. So we've heard today from Kathy mostly about the litigation going on at the state level. We hear stories about healthcare facilities that offer abortions closing in states or changing their services, as we have seen in Alabama. But what about local health departments? How are they responding to these changes? So we decided to conduct a mini environmental scan by reaching out to local health departments throughout the country to talk to them about reproductive health services and what they offer and how that may have changed or not changed since the Dobbs decision. And I conducted 5 interviews so far. And I'm also going to start with a pitch that if any of you work for local health departments or know anyone who does, who would like to participate in these interviews, please feel free to reach out to me at any time. The interviews take about 60 to 90 minutes and are conducted via Zoom. There we go. So this map is from Guttmacher and shows the basically the lay of the land for abortion restrictions right now, and was current as of October 10th. And I used this map to really inform the selection of local health departments. I wanted the local health departments to be geographically and politically diverse. I wanted them to reflect communities that reflected America and the United States, right? That were present not only in states that permitted abortion, but also that outlawed abortion in big cities and rural communities, and also in tribal nations. And this is also from a Guttmacher study. This is the monthly abortion access study, and it is a study showing the change in states from 2020 to 2023 and the increase, decrease, or change, I guess we would call it, in abortions provided. So this study also informed the jurisdictions selected, especially one specific jurisdiction that I will go into. So these are the jurisdictions that I have spoken to so far. So we have the Chicago Department of Public Health, located in Illinois, and abortion is legal in Illinois. We have the New York City Department of Health and Mental Hygiene. Abortion is legal also in New York, both large cities in states where abortion is legal. We have a tribal nation with members in multiple states, and some of those states where abortion is legal and some where it is not. And we have a mid-sized city in a state where abortion is illegal, and a public health department serving over 1 million residents in a state where abortion is legal. And as you can see in the last three, those local health departments did want to remain anonymous so that they could speak more freely. So I have anonymized those details as best as I could. The final jurisdiction was selected because it is a state that health department is located in a state that saw a very high increase in the number of abortions provided in that Guttmacher study, much higher than would have been expected. So what did we see in speaking with these jurisdictions? So in New York, the local health department didn't have a very big focus on reproductive health services specifically before the Dobbs decision. Following the Dobbs decision, they now have a free walk-in access to medication abortion in almost every borough. They also have abortion hubs where everyone can call in and ask questions or chat with the abortion hub at almost any time and ask questions. Chicago also had very little focus on reproductive health. They now have an Office of Reproductive Health. They have city funding to Planned Parenthood of Illinois and the Chicago Abortion Fund. They're training providers, and they're offering more services at Chicago Department of Public Health clinics. In the tribal nation, they already had incredibly comprehensive family planning services, including long-acting reversible contraceptives like IUDs and implants, and vasectomies, which are not reversible necessarily. But now they're doing increased community discussions, and they have their advanced practice pharmacists dispensing medication abortions in the states where that is legal. They also have their community health representatives able to drive their community members to surgical abortion appointments when that is necessary. But mostly they are listening to their community members and seeing what is needed in that community. In that mid-sized city in a state where abortion is illegal, they previously had no family planning services at their clinics, and now they are hiring advanced practice registered nurses and providing contraceptive care. So they are actually increasing the services that they are providing to their community. And in the public health department, where abortion is legal, they previously provided comprehensive family planning services like on-demand walk-in, reversible, long-acting reversible contraceptives. And they have taken no real change. They are hiring more APRNs to provide services, but they have not taken any further steps to provide medication abortion or funding to abortion funds or anything like that, like some of the other states have done. So some of the major themes that I saw in speaking with these local health departments, number one was polarity, right? We talk about red states and blue states. And really, when I spoke to these representatives from the local health departments, it seemed like the blue states were getting bluer and the red states were getting redder. When I spoke to New York and Chicago, right, states that where abortion was legal, they were becoming havens for abortion services, especially in a city like Chicago, which Stephen discussed. You know, Illinois is pretty much an island in the Midwest at this point, with Ohio really potentially coming up soon, perhaps. But Chicago becoming this little sanctuary, and Chicago, you know, really providing these services and doing more, and New York doing the same as well. And then in the state where abortion is illegal, you know, they can't say that word at all. So they have to really think about how they can provide services to their community without even treading on that subject at all. And the next major theme I saw was support for and from their community. Really what I heard was, we don't care about what the national debate is. We want to provide the services that our community is asking for and that our community needs. And if our community is asking for free walk-in medication abortion, that is what we are going to provide. And if they aren't, we are not going to provide that. I also heard that there were not many complaints about access to care or information. And if there were, they were providing additional access to care and information as quickly as they could. You know, they were responding quickly to the needs of the community. And that was really what was driving these local health departments, was responding to the needs of the communities that they served. So the next major theme was preventive services. And I want to conclude a little bit with some of the quotes that I took out of these interviews. So we take care of ourselves, and that's the purview of local health departments. We stay the course, make sure our communities know that they can access resources, getting people to primary prevention points so they don't get to a point where they have an unwanted pregnancy. This is the purview of health departments. This is the purview of local health departments. And finally, optimism. We saw that there was a threat to a basic form of care. We felt very strongly that everyone, not just our constituents, should have access to that care. There's a strong belief in a reproductive justice framework. One person wanted everyone else to know we're not alone in the struggles we are facing. I feel like if I got shut down, no one else will offer the services we offer. This is one of my favorites. This is work I thought I would have to leave government to do. Made me proud to be a government employee that day, to offer these services that we're offering. If we don't talk about it and what we're doing, we'll never see change. And this is actually the one that really got me. You can do a lot of work behind the scenes, and that's not a weakness. You don't have to be the one speaking out if that's going to hurt your position, but you can support those who are. So optimism about being able to support your community from whatever position these local health departments are in, whether that's expanding access to family planning services, because that's politically where that state is, or going as far as the politics will allow, responding to the needs of the community. And really, that's where these local health departments are. And they're finding optimism in that. And I just really love that. In, the news that we get every day about litigation and, the bad news out of Texas that we got yesterday and the day before, and the good news before that, with how everything is changing, just seeing that, our locals are really staying the course and providing those core services that they have always provided. And some are taking it a bit further, but they're really just staying there for their communities. So I really just wanted to spotlight New York and Chicago for their amazing work in this space that is really above and beyond what many locals are doing. NYC.gov/abortion, they have their abortion access hub with a live chat option, information on funding abortion care, information on access to abortions and funding for immigrants and avoiding fake clinics. And then Chicago.gov/abortion care, which has this amazing reproductive justice statement. So that's where we are. And thank you. And I'm going to pass it back to Catherine to get us started on some Q&A.
Great. So as the moderator, I'm going to indulge in asking the first question, but this is another reminder to just get any further questions you have in the Q&A box or in the chat. So this is for everyone on the panel. Your presentation's focused on what is happening at the state and local levels, but how about federally?
Stephen, you want to go first?
Sure, I'll jump in. And thanks for that question, Catherine. We have seen quite a bit of activity on the federal level. Last summer, after the Dobbs decision, the Biden administration issued a couple of different, well, at least one executive order, and then the Office of Civil Rights, which is the agency that enforces HIPAA, also issued some guidance on the application of HIPAA in the context of reproductive health. And OCR, in that case, took the position that HIPAA was sufficient to protect reproductive health information. I thought that was an overly optimistic assessment. They focused on certain provisions within HIPAA that they said were narrowly tailored to protect the information, which was a little unusual wording, but nevertheless, OCR did then issue a notice of proposed rulemaking this spring in which they asked for comments on proposed changes to HIPAA that would specifically prohibit the disclosure of reproductive health-related protected health information in the context of investigations and prosecutions. And so we will see what happens with the final rulemaking. The network did submit some comments in support of the changes, as did some attorneys general around the country, and then another group of attorneys general around the country also submitted comments in opposition to the changes. So we will see what comes of the changes to HIPAA.
And the Biden-Harris administration has been incredibly vocal in support of reproductive rights. Stephen mentioned the HIPAA notice of proposed rulemaking. They just came out with a request for information on over-the-counter contraceptives. They've done a lot of work with the VA members and access to abortion, suing the state of, I believe, Idaho on an EMTALA issue. So just a lot of support from the Biden-Harris administration on a federal executive level rather than a state or local public health level.
I think, as just to pick up on the, the piece that Joanna mentioned about EMTALA, I kind of talked about one of the cases, but skipped through my last slide on that in the interest of time. But there is litigation, again, really addressing this question of, very restrictive state laws on abortion and the kind of interference with EMTALA. So let's just say we're in a 6-week ban state, a pregnant person presents to emergency room at 11 weeks, and they are, they're in the midst of miscarriage. They're not quite septic. They're not, maybe it's not life-threatening yet under the state's standard for when they might be able to receive medical care. But under EMTALA, the protocol would be to stabilize them, and that would be through, providing abortion care to facilitate the miscarriage in a safe way. And so when those two things collide, should EMTALA preempt enforcement of the state law? So we're seeing litigation on that. EMTALA does have a specific provision in it that says it doesn't preempt state law, but it was really designed to be more about specifics of state law and not something as broad as an abortion ban. But we'll see what the courts do with that. Thanks, Catherine.
Thank you all. So I'm going to go to a couple questions from the Q&A box now. This first question is for Stephen. Have there been any cases where public health surveillance data on pregnancy status, for example, for interstate communicable disease reporting, was used by prosecutors?
That is a great question. I am not familiar with any instances in which that type of information has been obtained. State law around surveillance data varies somewhat from one state to the next. Some states, for example, their law will state that the information cannot be used in any proceeding of any kind. And other states will say that the information can't be subpoenaed. But all of these laws will have exceptions to the privacy restrictions. So I guess we will wait and see, but hopefully we will not see health departments having to turn that type of information over.
Thank you. This next question, I believe, is for Kathy or Joanna as well. Has there been any state referendum that a pro-choice initiative has lost when abortion was strictly on the ballot?
So I think I'm going to have Joanna chime in on her work in this space as well, but I'm not aware of any, right? So I'm not aware of when voters have been asked the question of whether they wanted to embed essentially the principles of Roe versus Wade in their state constitution, that those that a ballot question has been rejected. The network does have some resources on what's been going on in the ballot with respect to reproductive justice. What's interesting is some states are finagling with their ballot process, generally should try to avoid allowing those questions on the ballot. And that's my warm handoff to Joanna for a little bit more on that.
Yeah, so I recently published a resource on states that are changing the ballot initiative process in general to make it more difficult to get ballot initiatives even off the ground, and some specifically even for abortion. So Mississippi even put in an amendment that they would not allow ballot initiatives specifically for abortion questions. So that amendment did not go anywhere. But the interesting thing, to Kathy's point, is that none of those changes went through either. So not only did none of the did abortion win on the ballot, but none of the measures that would restrict the ballot went through either. I think Arkansas did, but usually they do not go through, as we saw in Ohio.
Thank you. This next question is for Joanna. Is there more information regarding tribal nations and what they're able to access and do within the states they are at?
So I am currently researching that issue. So stay tuned for some more information on that, because that is a complicated intersection of many areas of law.
So, right, I mean,
As
Joanna's looking at this complicated kind of legal structure. I think shortly after Dobbs, the reaction was, oh, well, a different constitution, right? The tribes, aren't governed on tribal lands by the United States Constitution unless they choose to, with their own, documents. Everyone can just flee there and get abortion care if they can't get it in their state, if a tribal land is accessible. And that ignores the fact that because of historical systemic marginalization of and lack of appropriate funding for healthcare on tribal lands, people who are on tribal lands don't get access to the care that they should be given. So we certainly don't want a situation where, privileged people find themselves, oh, let's just go to tribal lands so we can get our, access to reproductive justice. Let's focus on getting, tribal communities access to the healthcare that they deserve across the board. Sorry, just had to bully pulpit that.
and to play off of that, right? A lot of times healthcare provided on tribal lands is provided by the US federal government, right? Which does not provide abortion care. So it would only be available if the tribe provided their own care with funding, right? So a complicated legal issue that we are looking into. Stay tuned. I apologize for the southern exposure, son.
All right, this next question is for everyone. Are there any predictions for major themes you expect to see in the states next year? A related question to that is if you've seen any model legislation from anti-abortion groups that you expect to see cropping up in states next year.
I'll just say from the kind of state law perspective, I have not seen model law, and it's unusual in some respects because we are used to ALEC and others, providing model kind of more conservative policy. What I expect to see from a litigation perspective at the state level really centers around the language used in various state laws with respect to exceptions, because in the states where there have been unsuccessful, challenges constitutionally, and they've gone through another legislative cycle without being able to repeal or, amend a very restrictive law. They're looking to other avenues, and litigation is that. And I think looking at things like vagueness and the religious challenges that I referenced, that's a tough one for the Supreme Court to resolve, because the Supreme Court has really given, kind of a broadness to First Amendment religious freedom, or freedom from religion, free exercise rights, but here it's going to conflict with another kind of piece of Supreme Court jurisprudence. And so I think the religious-based challenges will be an interesting one to follow. But those vagueness and application, because again, I think the medical community has finally kind of stepped up to say, we have to be part of this because we don't know what that law means. And we can't call a lawyer or a judge to figure out whether and when we're permitted to provide often emergent medical care. I mean, we can leave aside, the Kate Cox situation in Texas, which is, it's reprehensible. And I hope that it doesn't, I know that it gets repeated around the country. I hope that through litigation, folks can at least prevent some of that. I hope we don't see that kind of litigation, because she shouldn't have had to do that.
I will add that I'm sorry, Joanna, did you want to jump in? I think we will see the final rule on HIPAA, which we don't know when exactly that will be issued, but I think in the new year we could expect it. And so we'll see what that looks like. I think on the state level, we will continue to see more state laws on protecting reproductive health data. I think in the summary that I presented, I think the most recent one was maybe November. And so I don't see any reason why that trend will not continue. And there are many different facets of privacy of reproductive health records, as you guys saw in the slides. that even states that have passed laws to date may pass some more because there are many different facets to it. As I say, there are continuing concerns around interoperability of systems and how that might impact state efforts to protect the privacy of reproductive health records. Also concerns around website and app data that collect consumer health information relating to reproductive health. And I think we may see some FTC enforcement actions. I'm kind of looking at crystal ball at this point. We don't know that, but it's entirely likely that we could see some more FTC action, hopefully around consumer health data collecting apps.
I also think, we will see more legislation that hampers the ballot initiative process, in these kind of subtle ways. And I think that's not only just having to do with reproductive rights. I think it has to do with a younger, more mobilized electorate that is becoming more and more different from who represents them, right? So it's not only reproductive health, it is Medicaid expansion, it is marijuana legalization. It's those things that, are kind of 55% of people are in favor of, but maybe their elected representatives aren't. So those issues that are being passed by ballot initiative that legislatures are kind of opposed to, that these legislative initiatives are making more difficult, but in very subtle ways, right? By increasing the number of counties that you have to have signatures from, or by increasing the percentage of signatories, things like that. So that's what I would say I foresee, and I would encourage people who live in states with those initiatives to be on the lookout for those subtle changes.
All right, thank you all. I'm going to go to one from the chat. This is for Joanna. In your discussions with local health departments, did any of them act as an intermediary to distribute mifepristone from manufacturers at no cost to other prescribing providers or to pharmacies? Is this intermediary action prohibited under REMS?
None of the local health departments that I spoke to did, no.
All right, thank you. Another question that is for Joanna, I believe, but could go to anyone. Are there examples of how a clinician can get someone across state lines to access care when they cannot say the word abortion? It seems to be a client's right to know that they have free movement across state lines to access care. And a related question is what relief or services can specifically be given to those BIPOC people who don't have the resources to travel outside of a state like Texas to get an abortion?
So there are ways to do it. And there are ways to do it by saying, like, here's a list of phone numbers that you can call, here's a list of resources that you can call, or here's some websites. And that's typically the way that I have seen that providers and clinicians do it without uttering the word. Kathy?
Yeah, I mean, I agree with Joanna. It's a tough call. I mean,
yeah,
it evokes in me, kind of states are now kind of the other end of that coin is trying to regulate crisis pregnancy centers that are giving people bad information, right? Misrepresenting issues associated with pregnancy and abortion care and the like. And so on the other end of the spectrum is how to, make sure people who, because medical professionals are either, legally constrained or feel legally constrained from, providing information about abortion care that could be available outside of the state. So I think, number one, it is the space of public health at the local level, at the state level, community, organizations, and making sure individuals understand when and where abortion care is accessible. That's only going to help a little bit. The question about, BIPOC and other marginalized communities who don't, it's a joke to think that even before Dobbs, that individuals had ready access to all of their reproductive health care needs, because we know that is not the case in many of these states that have now outright banned abortion. For the most part, they functionally had, severely restricted access to abortion. And I read a piece recently about the use of GoFundMe for, kind of medical care in this country, and the insanity of that. That's what we do in this country when somebody needs support in a medical situation. So it just makes me think of, if you're looking for an end of year contribution to make to a charity or a gift to provide someone who cares about these issues. Just me personally, this is not the network saying this, it's me, find yourself a good abortion fund that provides that type of resource. And there are many that are targeted towards certain communities. Indigenous Women Rising is an organization I've worked with that supports tribal communities, but there are many others. And so sadly, we are in a situation where kind of the structural racism and marginalization in this country that has interrupted, good health for, certain populations in many ways is becoming even worse in this situation. I wish I had a legal answer to that question.
I do want to make one more note that if the local health department or the provider is a Title X grant recipient, they do have to acknowledge that abortion is an option in their options counseling. That is required by the Biden rules. So one important note.
Thank you both. A follow-up on that for Joanna is that for local health departments that are receiving that Title X funding, are you seeing any that are feeling cautious about providing reproductive health care or contraception due to the restrictions in Title X?
I certainly am. Hi, Brianne. Great question. Yes, very much so. And I'm going to be providing a resource on that. Because that is definitely a big issue. And I think as someone who worked with a Title X grant recipient for a number of years, I think there is a line, drawn by the regulations about what grant recipients can say. And I think that line is here. And I think, everyone kind of goes to like here. So kind of marking where that line actually is for those grant recipients is really important, so that providers can say as much as they possibly can for their patients and give them as much information to make truly informed decisions would be really beneficial.
Great. Kathy, I believe this is for you. Could you speak to conscientious objection laws and how states where abortion is legal are making sure that people who are declined care can still access it in a timely manner? Are states passing legislation targeting the information environment in that manner?
Yeah, so I saw that question in there. I was hoping you'd ask somebody else, but and also because I don't know the answer to that question. Whoever the requester is, if you just shoot me an email after this, I will take a look into the question because I honestly, if I wasn't being recorded, I might make up an answer. No, I'm joking. I really don't know the answer to the question. Every state has different laws with respect to whether, when, and how someone can decline to provide health care, because of typically a religious or philosophical objection, and then what's required as a result of that from maybe the healthcare institution having someone else who could provide that care, but it does vary. And I do know that in rural communities, some of those laws are completely ineffective because there's only one healthcare provider. So if they have an objection, there's really no one to step into place. But I'm happy to explore this with you, so shoot me an email. I don't know if Stephen or Joanna had anything to add there.
I do not. Thank you, Kathy.
I do not, but happy to work on that with you, Kathy, when you get the email.
Okay, this next question is for anyone. Are concerns around anti-abortion states moving to target contraception and assisted reproductive technology next likely to be realized?
So let's separate that out into contraception and then reproductive, assistance. I think there is legitimate concern that in some of the states that have been emboldened now by having their, incredibly restrictive abortion ban laws upheld and now in effect for periods of time, and they've essentially run out of their state, virtually all abortion care providers, that I do think next on the block, this is where I would expect to see some model legislation per your earlier question, but I haven't, that access to contraception, or at least perhaps types of contraception, will be proposed. They'll always be proposed by fringe people in state legislatures, but I'm suggesting that they could be proposed and actually have some wind under their wings. And that's the concern about the way the Supreme Court decided the Dobbs opinion, really giving some, at least credence to that the other decisions that they've made under that right to privacy in the 14th Amendment might also be overturned. I will say the concurring opinions that allowed Dobbs to become a majority hedged a bit on that. And so I'm not sure the Supreme Court is ready to do that. Access to reproductive support, or I'm not sure what the right word is here, but people who use other reproductive technologies, there's a fine line here. I do think that there is a, in some of the same communities that want to prohibit access to abortion and contraception, to do the same there. But because that is mostly used by people of means who have political power, I actually don't see that becoming realized, because people with power and money are more likely to get their way in the legislature.
Thanks, Kathy. All right. A question from the chat. How would we label a list of out-of-state resources that did not use the term abortion and also makes it clear what services we're referring people to?
Reading the full question. If the requester wants to send me an email, we can set up a time to talk. I have some ideas about what we can do.
Great. Okay, another one from the Q&A box. Do any of you work with maternal mortality review committees and can explain how these laws may change how these committees function?
So I haven't. Sorry. No, go, Stephen.
Well, I was going to mention, I think in terms of peer review, most states have a peer review privilege law that privileges the information that is discussed in peer review. There are requirements that have to be met in order to be able to exert that privilege, and there is many a case in which people goofed up and did not observe the requirements, and so the information was not privileged. But I guess that would be my advice for folks would be to consult with their counsel around peer review privilege, and to determine, if any steps need to be observed in order to make sure that the information that's reviewed during a maternal mortality review is not subject to discovery.
The reason I love doing this as a group is I never would have thought of that aspect to the answer to this question. I'm always impressed by my colleagues. Thank you, Stephen and Joanna and Catherine. My thought is I have worked with the Maternal Mortality Review Board here in Maryland just as another aspect of my job, but I also do some work in maternal health disparities. What I see coming is obviously for maternal mortality review teams that there's going to be more maternal death, more morbidity and mortality associated with pregnancy, particularly in the states where those numbers are already terrible, and the disparities between white people and people of means as compared to people of color, particularly Black people, in that, there's going to be more work to be done there. And I just encourage folks who are in that space, obviously without breaching the confidentiality and privacy that Stephen has referenced, to make sure that the numbers are being publicized and that we're able to, to really look at them, because the reality is, these laws will result in more maternal death.
Thank you, Kathy. I believe that is all the questions we have time for. And so thank you all.
Daniel, you got your words? Yeah.
Yeah, so thank you everyone for attending today's webinar, and thank you to our panelists for giving such an incredible presentation, and thank you to Catherine for helping facilitate a great question and answer session. So all attendees will be receiving a copy of the slides as well as a recording of the webinar in about a week. You're running with the holiday season, things might get pushed a little bit around with people being in and out of the office, but we should have hopefully it up by next Wednesday at the latest. And you will also be receiving an email when those have been published, along with a link to the slides as well. So once again, thank you all for attending, and we look forward to seeing you at our next webinar. Thank you all.
Bye, everyone.
Thank you.
Happy holidays.
Thank you.